Buckle up, guys. Today we are going to witness the absolute chaos that unfolds when one of the most stubborn, self-assured individuals enters a virtual courtroom. Right from the start, the stage is set for confusion as the narrator teases the ultimate Karen in all her glory. You immediately sense tension bubbling under the surface because this isn't just any traffic ticket dispute, it's a collision of arrogance, ignorance, and technology. The initial setup perfectly hooks
Mason, really
Mhm.
quick before you mute.
Uh-huh.
Um, so what we're gonna need from you right now, since this is virtual, make sure that your phone is stable. Don't be walking around your house or none of that. That's what the judge requires, okay? Make
Okay.
sure you have a stable internet connection. Um,
hmm
Otherwise, if your internet doesn't work or whatever the case be, then the judge will just cut the cord out, okay?
Okay.
Obviously you
Because
don't want that.
just
Yeah.
FYI, I have not had no issues with my
Okay.
internet, my tablet, so if it do it today, that's just like wow, what a coincidence. But I
Right.
I haven't had no issues. But thank you for letting me
No.
know.
Okay, so we're on the record for August 7th, 2025, and we have two cases on the docket today, one defendant, but two cases. Um, Ms. Mason, you're going to have to turn on your audio if you would, please. And these are cause numbers um, LBZ 588-056-1250 and LBZ 588-056-1359, both style of the state of Texas versus Barbara Faye Mason. Ms. Mason, are you able to hear? She says she can't hear you. Okay, well, her internet's not. Ms. Mason, you're going to have to turn on your audio and yeah. Okay. Well, Ms. Mason, the problem is we can't do virtual if your technology doesn't work. And so the request to do this yeah, okay. Ms. Mason, unless you can get your audio to work, we're going to have to reset your case and you're going to have to appear in person. All right. Would you send her? I don't know. It's not me.
Here, the courtroom formally begins, and the first signs of
Well, Ms. Jordan, my audio is working. My video is working. You're gonna need to send her a message saying that unless she can get her audio to work, we won't be able to do this by Zoom, and she will have to appear in person. Well, I'm not sure what to tell you, Ms. Mason, but yeah, ours is working on this side. Ms. Jordan, are you able to hear me?
Every word.
And Officer Edge, are you able to hear me?
Yes, sir, I can hear you.
Thank you. Ms. Mason, while the other people on the Zoom call are able to hear me, but if you can't communicate it, okay.
You may be trying to log in on her phone.
Your Honor, we're going to have an exhibit in this case. While she's logging in, can I bring that down to have that emailed to her?
Yes.
The comedy of errors truly begins here. Mason's audio mysteriously fails as the judge attempts to start the record, creating
It
immediate
sounds like, or it looks like you're having internet issues, and if we can't hear you, whether it is on one device or another, if we can't hear you, then this can't proceed, and we'll have to set this case for an in-person trial. And I understand that you're telling me that it's our side, but both the parties, the state and their witness are able to hear me.
Sir, can you hear me?
I can.
I find it very strange that I have not had any problems at all until you came on, and now all of a sudden my audio was messed up. But I logged on, and now everything is working fine. That's I guess that's technology for you.
Yes, ma'am.
I'm ready.
Well, I don't know what your
I'm having to use two phones. My tablet was working fine. I had just told the what is the deputy before he was explaining to me. He said make sure your internet and all that was working. I have not had any problem with my internet until you popped up. I just find that weird.
well,
And I guess
I'm not
that's
sure if
just
you're yeah.
it's a technical thing.
Yeah, I don't know yeah. I'm not sure what my addition to this call caused or created, but I am an essential part of this process, and so Ms. Mason, have you received a copy of the complaint? That's the written charging instrument. Have you received a copy of the complaint in this case?
I just received it in email today. Let me
Very
stop
good.
one of these. Hold on.
All right, and so at the appropriate time, I'm going to ask the prosecutor to read the complaint, and then I will ask you how you want to respond to the charge. In this case, there are two cases. There is a failed to signal charge, and there's a failed to display charge. And so I will
I
ask
only
you how you want.
received one.
Just, pardon me?
I only received the driver's license, the one for the driver's license. I didn't receive the complaint for the illegal turn.
All right, well, we'll send that to you.
Okay.
So, Ms. George, excuse me, Ms. Mason, you are not represented by a lawyer today, correct?
No, I have no money. I don't have money for a lawyer.
Well, the court is not allowed to assist you in the presentation of your case. I can't tell you what questions to ask. I can't tell you if or whether you should testify yourself. I'm just not allowed to help you in the presentation. Do you understand that?
I do.
Okay.
And like I said, I'm not a seasoned police officer or prosecution. I'm only a person, that does right by the law. So I can only do my best.
Well, the reason I tell you this is that I just want you to understand I'm certainly not going to help the state, but I also can't help you in the
I
presentation
know.
of your case. Okay,
Trust me. I know Denton County well. I know you can't help me. I know you can't, and I know that I'm.
At this point, stakes increase as the judge warns Mason that if her audio doesn't work, the case will reset for in-person trial. Mason's defensiveness and blame
at the appropriate time, I'm going to ask the prosecutor to read the complaint. And you have the right to call witnesses on your behalf. You have the right to testify on your behalf. but you have no obligation to put on any sort of case whatsoever. Do you understand that?
What do you mean by put on case? I don't know what you mean by that.
Okay, what I mean by that is you have the right to testify and tell me what you want me to know. Tell me what to offer evidence on your behalf, but you're not obligated or required to do that. That the state has the burden of proof in this case against you, and they always have the burden of proof, and so you're not obligated or required to say anything. You have the right to say and to testify on your behalf, but you're not required to do that. That's my point in explaining this to you. Okay?
Okay. And let me ask you some. I want to go back to the first time and when I had my first court, when I asked for the dash cam video and his body cam video, because those actually prove my point. And I was told by the lady prosecution that I didn't get to get that. I had to bypass all that because I missed it. So therefore,
okay, when we send out a notice for court, we send it out with a lot of lead time to tell the person, if you're going to request discovery in the case, that we have to reduce that request to writing. You have to serve it on the other party, that in this case it would be the prosecution, and it has to be done at least 7 days before the hearing. And if you didn't do that, then you waived that right to request discovery. Now, she has an obligation to provide any exculpatory evidence, make you aware of that. But if you don't make a timely request, then you lose that right to file that, or you lose the right to have that discovery prior to the day of trial.
so my question is, you're basically telling me that because that was missed, I don't get to get the proof that I need. What I'm getting ready to tell you what he said and did, and it's all on his dash cam and his body cam of the interaction that we had. So I'm just making sure, and I'm sorry, I'm not, like I said, I'm not a seasoned prosecutor or defense attorney, so I have to know this.
Well,
if you don't mind.
What I'm telling you is that had you brought this issue up, so I'm responding to you. Had you filed your motion for your request for an inspection of the video prior to the day of trial, you would have been able to get that information before the day of trial. Okay.
So that's a no, right? So that's a no. I won't be able to get that.
If the prosecutor presents it, you have the right to use that and to point out if there are any inconsistencies. You have the right to use that as part of your case.
Okay, so let me ask you another question. So you're basically saying that the complaint that I got, because I missed requesting that. So the only thing that we're going to go by is what he's saying, what's on that document, what's on the ticket.
Now we reach the first classic Karen moment. Mason openly claims that her internet only failed because the judge appeared, an assertion that defies logic yet defines her persona. The courtroom tension escalates because this is no longer a procedural issue, it's personal and emotional. You can feel the absurdity, but also the drama, as authority and defiance.
I'm saying that the state has the burden of proof in this case, and they will present their side of the case. When they rest, you have the right to present your side of the case.
Okay.
And you can tell me what happened. You can present evidence. You can call a witness if you want to, and whatever evidence is admitted, the court will consider that and review that and use that to make a determination if the state has met its burden of proof in this case. Okay, that's how this process works. And so I'm not saying you can't present your side of the case. I'm saying that the opportunity to review the dash camera video and the body camera video prior to the day of trial was waived because you didn't follow the instructions we gave you a month and a half before you're supposed to have a hearing.
I didn't follow the instructions. Hold on. I didn't file
No,
a
ma'am. No, we're not going to continue to do this. There's been a ruling on it. And when a judge makes a ruling, if you disagree with it, you can appeal it to a higher court. That's how the process works. And so you don't,
court? Are you
pardon
saying
me?
a Texas court? Republican Texas? Come on, Judge. Okay, let's go ahead and
Ms. Mason, those are, we're not going to do this. I'm not going to have you make sidebar comments throughout this trial. We're not going to do that. And I'm going to ask that you use this or go through this process orderly. I will give you an opportunity to present your side of the case, but I'm not going to have you make sidebar comments. Please. Now, Ms. Jordan, would you please read the complaint part? I'm sorry, let me back up for a moment. Do you have any pretrial motions that you want to present at this time?
We do, Your Honor. It's the state's understanding that Miss Mason appeared for trial previously, and when she appeared in person for trial, the case was reset, and she asked that the next setting be on Zoom. And so we would like to put on the record that the state has no objection to proceeding with this trial on Zoom today and make sure that all parties are in agreement of Miss Mason's request.
Well, if she requested it and you agreed to it, I think
Yes, sir. I
we're
believe there's some law that indicates that there has to be an agreement on the record for Zoom, and so I just want to make sure we have everything perfect.
all right. Miss Mason, you did request a trial by Zoom, correct?
Well, that was
Virtual
after
trial.
you gave me that option. You gave me the option when we reset the court.
Yes, ma'am. And so you elected this option, correct?
Yes, yes.
All right, very good. Thank you.
Thank you, Your Honor. Our second request is we're asking that the court take judicial notice of the fact that Miss Mason did not request discovery either directly through a motion with the court or through a request directed directly to the state. We would ask that judicial notice be taken of that fact.
Granted.
Thank you, Your Honor. No further pretrial motions for the state.
Ms. Mason, do you have any pretrial motions? These are motions prior to the beginning of the presentation of the evidence. Do you have any pretrial motions you want to make at this time?
Well, as I stated, I'm not a seasoned prosecutor, but when I did find out, read the paper, this was not stated to me while I was in court. It was written on your paper that I had to read. My understanding was that the court was being reset.
Here, the courtroom formally begins, and the first signs of tension appear. The judge carefully lays out Zoom protocol, emphasizing stable connections and proper audio, but Mason's insistence that everything is perfectly fine already hints at the friction ahead. You can see the subtle comedy and drama forming. The court is trying to maintain order, yet technology already threatens to derail proceedings. It's a classic setup: authority versus overconfidence. The judge's calm instructions contrast sharply with Mason's casual defiance, signaling the struggle that will define this case. Every repeated clarification from the court builds suspense. You start realizing that this isn't just a procedural warning, it's the calm before a storm. The audience gets a clear sense that Mason's confidence may be her own worst enemy. This part balances procedural seriousness with anticipation of the case.
You do that in just a little bit. When the state, because I said earlier, because the state has the burden of proof in this case, she's obligated to present her side of the case first. Then you have the right to respond. You have no obligation to respond, but you have the right to respond. And at that point in time, you can cross-examine any witness. You can present whatever evidence you might have in your case. Okay?
Okay.
Ms. Jordan, would you do you want to make an opening statement?
Your Honor, the state waives opening statement, but we would like to present or ask the court to admit into the record State's Exhibit number 1, which has been labeled State's Exhibit 1A through State's Exhibit number 1G as a self-proving document.
We're going to have to get Ms. Mason a copy of this since we're doing this by Zoom, and this is confidential information, or at least private information. I don't want to present this on the screen, and so we're going to need to send this to her by email so that she understands and can respond to your offer of State's Exhibit number 1.
Yes, Your Honor.
Ms. Jordan, can you, do you have an electronic copy of this?
I do not. I have to request a physical copy from DPS and they send one through the mail. Your Honor, would you like me to continue on with testimony with the officer and then I can revisit that once she's received it?
Let's go ahead and do that.
Yes, sir. The state has no opening statement.
All right. Ms. Mason, you'll be allowed or you'll be permitted to make an opening statement once the state has finished its side of the case and rested. At that point in time, you can make an opening statement or you can proceed directly with your evidence in the case. Okay? Ms. Jordan, you may call your first witness.
Thank you, Your Honor.
Here, the judge carefully explains Mason's rights, the burden of proof, and trial procedures, but the confusion is nearly palpable. Mason interrupts repeatedly, misunderstanding basic legal concepts, and the tension grows with every miscommunication.
Barbara Faye Mason.
I was. The initial contact was, I first observed the vehicle in about the 100 block of North I-35 southbound, and the significant traffic violations happened in 1300 block South 35 southbound. So I was in a marked patrol vehicle. I was getting onto 35 from the southbound frontage road just north of Main Street, and I observed a Nissan sedan make multiple lane changes from the number 4 lane, the far right lane, all the way over to the number 1 lane, the far left lane, without signaling. I did not take enforcement action at that time. As we continued down the highway, I observed the vehicle again change lanes from the far left lane all the way to the far right lane without signaling again, take the exit for corporate, make a lane change again without signaling, and the first time that the vehicle signaled was as it began its turn onto the cloverleaf for corporate.
And Your Honor, at this time, it might be a good pause to go back because the body cam is labeled as State's Exhibit number 2. We did label the abstract driving record as State's Exhibit 1. Has she received that a potential exhibit yet?
Ms. Mason, have you received, if you check your email, have you received that
I'm
email
looking now.
from the court for State's Exhibit number 1?
Let's see. What is this? This is, hold on. I'm opening it up now. Okay, yes, I do see that.
Very good. All right. So Ms. Mason, do you have any objection to State's Exhibit number 1 being admitted into evidence?
Yes, I do. What is that? What is this Texas Department of Public Safety? What date is that dated?
Well, you have the document. If you'll look at the second to the last page, there's an affidavit there. It's dated May 15th, 2025.
May 15th, 2025.
Yes, ma'am.
What do you mean? This is when they sent this to me, May 25th, 2025?
No,
No, when
ma'am.
was this? The actual letter. The Texas Department. I don't see the date up here.
Okay.
I don't see the date. I'm trying to see the
What is
date.
what is your objection?
My objection is this doesn't have an actual date on it. So when was this made? And that's my objection because I have a reason why this is there and it probably don't have a date. And
Yes,
so
ma'am.
I need to know, all I'm asking is, does it have a date?
Yes, ma'am. I just explained that to you. If you'll look at what appears to be State's Exhibit number 1F, that is the
1F?
Yeah, that is the certificate. And Ms. Jordan, it looks like you had G and F in out of order.
No, I understand the exhibits. I'm looking at, you see where it up top where it says Texas Department of Public Safety? This letter, where's the date for this letter?
Yes, ma'am. And this is a document that is a multi-page document, ma'am. And so this exhibit this document, exhibit number 1, has a date of May 15, 2025. So
okay, so are
I
you
need to know
saying
what
my
your